Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 scenarios involving easement, a key topic in land law under FLK2. Let's dive in. Caroline owns a registered freehold property. Her neighbor, a property developer, plans to build on their land, which would block the shortcut road leading to the main road. Caroline used this shortcut road continuously for 12 years, after which the neighbor explicitly gave her permission to continue using it. She has now used the shortcut road for a total of 21 years. The right has never been formally registered as an easement. Can Caroline successfully claim a legal right-of-way? A. No, because she only used the road without permission for 12 years. B. No, because the right has never been registered. C. Yes, because she has used the road for over 20 years in total. D. Yes, because she was later given permission by the neighbor. E. No, because permission defeats the possibility of acquiring the right by prescription. The best answer is E. No, because permission defeats the possibility of acquiring the right by prescription. To acquire an easement by prescription under the Prescription Act 1832, the use must be continuous for at least 20 years. As of right, which means not by force, not secretly, not by permission. Without interruption. Once permission is given, the use becomes precarious, by permission, and can no longer be as of right. Permission given during the prescriptive period defeats the entire claim, even if there was prior use as of right. The law does not allow mixed periods of prescriptive and permissive use to combine. Scenario 2. Caroline's neighbor is planning to construct a new building on their land, which would block her view from her window. For the past 21 years, she has enjoyed an uninterrupted view across the neighbor's land. However, this right has never been registered as an easement. Can Caroline successfully claim a legal right to a view? A. No, because the time of use was too short to establish the right. B. No, because the use was without the neighbor's consent. C. Yes, because the time of use was long enough to establish the right. D. Yes, because the right does not need to be registered to be capable of being protected. E. No, because the right is not capable of being an easement. The best answer is E. No, because the right is not capable of being an easement. English property law does not recognize a right to a view as an easement. While some easements can be acquired by prescription, with long-term use over 20 years, the key requirement is that the right must be capable of forming the subject matter of a grant. This means it must be a type of right the law is willing to protect as an easement. A right to a view is too vague, subjective, and personal to meet this requirement. It does not fall within the recognized categories of easements, such as rights of way. Therefore, even 21 years of uninterrupted enjoyment without permission will not create a legal easement for a view. Scenario 3. Caroline claims that the new building to be built on neighboring land would block the natural light entering her window. Caroline has enjoyed uninterrupted light across the neighbor's land for 21 years. The right has never been formally registered as an easement. Can Caroline successfully claim a legal right to light? A. No, because 21 years is too short a period to establish the right. B. No, because the light was enjoyed without the neighbor's permission. C. Yes, because the length of use is sufficient to establish the right. D. Yes, because the right does not need to be registered to be enforceable. E. No, because a right to light cannot be an easement. The best answer is C. Yes, because the length of use is sufficient to establish the right. Under English law, a legal right to light can be acquired as an easement by prescription if the light has been enjoyed openly and without interruption for at least 20 years. This is set out in the Prescription Act 1832. Registration is not required for a prescriptive easement to arise, though it may be advisable. In this case, the woman has enjoyed natural light through her window across the neighbor's land for 21 years, without permission. This satisfies the requirements for a prescriptive right to light, making her claim legally valid. This table illustrates key principles we walked through. For a right-of-way, continuous use as of right, that is without force, secrecy, or permission, for at least 20 years is required under the Prescription Act 1832. If permission is given at any point, it breaks the continuity and defeats the claim. In the case of a right to a view, such a right is not legally recognized as an easement at all, regardless of how long it has been enjoyed. However, a right to light can be acquired through prescription if it has been used openly and without permission for over 20 years, making it a valid easement even if not formally registered. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.